Welcome back to Winning Isn't Easy. Reliance Standard wrongfully denies the claim of a nurse anesthetist with Lyme disease and breast cancer. Many disability carriers just don't understand diseases like Lyme disease, or they may think that just because somebody has had breast cancer and has had treatment, that they can return to work. And often I see claims wrongfully denied or terminated because of that thinking, in quotes, if you will. So let me tell you the story about a nurse anesthetist and how her claim was denied by Reliance Standard. So you can have a sense of the games that disability carriers play and the tools that they will use in their denial toolbox. A nurse anesthetist administers anesthesia during surgical procedures so that you don't feel pain. You can be administered a general, a regional, or even given a sedative. Now, the type of the anesthesia that's given depends on the type and length of the procedure you're scheduled to undergo and your personal needs. I think we can all agree that your safety is crucial. And if the nurse anesthetist is having physical problems, that your safety can be in jeopardy, right? Now, diseases like Lyme disease can cause pain in the joints, muscle fatigue, fever, malaise, and even a headache. A nurse anesthetist who suffers from Lyme could easily make a mistake in administering anesthesia. Would you want them to administer anesthesia to you? Well, sometimes disability carriers don't think about those things. And let me tell you about Reliance Standard's conduct in a nurse anesthetist disability claim. Under the ERISA regulations, a disability carrier like Reliance Standard has to provide a full and fair review of a disability claim and an appeal. That means they can't cherry pick medical records to reach the desired conclusions of denying or terminating benefits. But of course, that's exactly what they did in the case of Jordan versus Reliance. There are lessons to be learned in this case, regardless of whether or not you have Lyme disease, because again, these are the kinds of games that carriers play with disability claims. So Jordan was a nurse anesthetist, became disabled as a result of Lyme disease that caused left-sided weakness, numbness, tingling, and burning from the scalp to the toes. She was paid benefits from October of 2009 until May of 2015, some 6 years, at which time her benefits were terminated. Now, in this 6-year period of time, the definition of disability had changed from an inability to do her own occupation to an inability to do any occupation. When her claim was denied, she filed an appeal, and Reliance Standard didn't timely decide her appeal. So she filed a lawsuit. And then while the lawsuit was pending, Reliance denied the claim on the basis that she did not attend an IME that they had scheduled. They filed a motion to dismiss her lawsuit because alleging that her claim was wrong and premature because she had failed to exhaust her administrative remedies because she didn't attend the IME that they had scheduled. So this case is in federal court, bounces around, and then the first go around, the court says, look, Reliance, we're going to send this claim back, and you can go ahead and schedule the IME, and you can issue a final decision. Of course, I hate remands, but of course, that's what the judge did. And of course, the alleged independent medical examination wasn't favorable. The liar for IME doctor concluded that she had the functional capacity to perform any occupation within any restrictions and limitations that existed in August of 2016. Now, Reliance paid benefits through that date, and then once again denied her claim on the basis that she could do any occupation. What was an interesting twist in this case is that in the course of this appeal, she began working on her master's degree, which is a 2-year program. The IME doctor, who wasn't familiar with the nature of the training program, concluded that, hey, if she can do clinical work, then she should be able to work full-time. The IME doctor made unfounded assumptions about the nature of her classes, the clinical work, what was required in evaluating patients, and that was the basis of their opinion that she could go back to work. And of course, Reliance hung their hat on that unfavorable IME. So Jordan appealed a second time, and she said, look, the IME doctor has made assumptions about this nursing education that's not correct. She provided a personal statement that outlined the fact that it took 4 years to obtain the degree, which was a 2-year degree. She completed the program with accommodation, including a reduction of the hours that she was required to perform the clinical work. She even delayed her licensing exam, which she obtained a year after her graduation. Now, in the meantime, despite all of this, she was diagnosed with breast cancer and underwent treatment. She returned to work as a nurse practitioner in September of 2017. So you got the basic facts here. Reliance Standard had her medical records reviewed by a physician that we all know in the ERISA world who is very, 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 very skeptical of Lyme disease. They had another peer-reviewed doctor who only addressed her breast cancer diagnosis. So guess what they did? Each peer-review provider made certain assumptions about her training, assumptions about significance of surveillance showing her holding a leash for her dog and bending over to pet her dog. Neither of these liar-for-hire doctors reviewed her treating physician's reports, disagreeing with their conclusions. And what was interesting is that the peer review reports clearly indicated that each doctor only reviewed her past medical records and did not consider her treating physician's responses or any information she supplied about her training programs. This failure would be the key to the court's ultimate decision to reverse this termination. Now, the federal court upheld the denial, and ultimately the case ends up in the Sixth Circuit, who reverses. So this case has been to federal court twice, and then up to the Sixth Circuit. The Sixth Circuit comes to the rescue, and they say that Reliance Standard's conclusory findings are not supported by credible medical evidence, and that they acted arbitrarily and capriciously. The court took a fine-tooth comb to the 11-page denial letter that recited in length all the prior medical records they reviewed. But this denial letter didn't address the treating physician's opinion, disagreeing with the peer review report, selectively considered her medical records, we call that cherry picking, and did not address that the surveillance that they were relying on in denying the claim was taken in 2015 when they were paying benefits. Ultimately, the court says, look, this denial letter does not pass the smell test. It doesn't adequately explain the reasoning and the inappropriate cherry picking of the medical records. The court said, look, this denial is riddled with errors and the very kind of mistakes that could kill a patient. We don't want to have to go to federal court twice and to your circuit court to get a favorable decision. So you can see that it really is crucial that you be represented by an ERISA disability attorney in the appeals process, and one who doesn't give up. The documentation that was submitted should have given Reliance Standard pause to look at this and do their job, but they didn't do their job, and that made it, and I'm going to put this in quotes, easier ultimately to convince the Sixth Circuit that they hadn't done their job correctly. Winning in front of conservative judges can be really tough. And that's why proof, in my view, is really important. You need to understand the nature of the disease, the objective evidence of the disease, establishing why a person can't do their own occupation. If they're attending schooling, explaining the nature of the schooling, explaining the length of time, the accommodations, explaining any attempt to return to work, providing functional capacity evaluations as appropriate, providing vocational opinions, laying the foundation for challenging a wrongful denial or termination of benefits. I hope you've enjoyed this week's episode of Winning Isn't Easy. If you've enjoyed this episode, please like it, leave a review, and share it with your family or friends. Subscribe, please, to this podcast. You'll know every time a new episode comes out. Got it? I hope you have enjoyed this week's episode, and we'll tune in to next week's episode of Winning Isn't Easy. Thanks.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy, with tips and to-dos that will assist you in submitting a winning disability application. This is one you don't want to miss. For the next 24 hours, we're giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.